My name is Bob Duncan, and I am the founder of Duncan Law Group, and I'm here today to touch on 4 things that I think you should know about pleadings as you start your career. The first is, what are the fatal flaws related to pleadings that you need to be aware of? And really there's only 2 things that you need to keep in mind. First, statutes of limitations. Know your cause of action, and know what the associated statute of limitations is. Make sure that you diary that statute of limitations multiple times in whatever record-keeping device that you maintain with your office. And then I'd also advise you not to let yourself get into the habit or practice of getting up until that point where you make a decision as to whether or not to file the case, settle the case, or do whatever you're going to do with it, because that is going to only lead to problems. Typically what I do in my office is I try to get everything to a point 6 months before the statute of limitations, and at that point we will move forward with filing the case, or at that point I'll know that the case is going to resolve. But ultimately it allows me the flexibility to make sure that I do the second thing that can be fatal to a claim, and that is get the case filed in time so that I can make sure that I identify all of the responsible or potentially responsible parties. Make sure that throughout your investigation of a claim that you're thinking about all of the potentially culpable parties, whether those are individuals, corporate entities, if there's an agency relationship, if there's an employment relationship, for example, in an auto case, if the owner of the car is different than the driver of the car. Those are all things that you need to keep in mind in order to identify the appropriate and proper parties so that all of them are named by the time the statute of limitations expires. As the plaintiff, you're going to be filing the complaint, and that's really what starts everything off. And so you need to be aware of what you need to do when filing a complaint. My advice is really threefold. Number one, identify all the potential causes of action that you have. Give some thought to different angles that you can take in terms of prosecuting the case. Think about what causes of action exist at common law. Think about whether or not there's any statutory causes of action that exist. Along those lines, the second thing that you need to do is make a checklist. Even if it's for a cause of action that you've pled tens or hundreds or even thousands of times, make a checklist regarding the prima facie elements of that particular cause of action. That way, as you draft your complaint and you allege your facts, you make sure that you hit every element that's required in order to successfully plead your cause of action. The reason I think that's so important is because it helps you avoid receiving a 2615 motion to dismiss from a defense attorney. Avoiding 2615 practice is important because it maximizes your efficiency, and it minimizes the expense that you incur on a case to have to go back and amend and replead. The third thing that I think is important when drafting a complaint, the initial document in any case, or virtually any case, is to think about how you want to frame your case. What facts do you want to allege? Clearly you want to make sure that you touch on every element of the prima facie requirements, but you also want to add facts that are going to be advantageous to your position moving forward. Think of a complaint as almost a quasi-discovery tool. Seek to elicit admissions from the opposing party. They're required to respond to each and every allegation that you make with either an admission or a denial. And to the extent that you're able to gain an admission at that stage in the litigation, it can very much work to your advantage. As a defendant, you'll be responding to a complaint, and there's a couple of tools that you need to be aware of. First, when responding to a complaint, conduct your own investigation, and whenever possible, file an affirmative defense. Affirmative defenses are pled just like the complaint is, so make sure that you plead facts to support the affirmative defense that you're moving forward on. But from personal experience, anytime an affirmative defense is pled in a case, it automatically drives down the value of the claim. So it's a benefit to your client each and every time you can put forth an affirmative defense. The second tool that's available, and very often overlooked by defendants, is issuing a demand for a bill of particulars. If the plaintiff's complaint is deficient in any way or lacks specificity in any way, issue a demand for a bill of particulars. It'll put the burden on the plaintiff to plead additional facts to support their cause or causes of action. It's only going to help you in terms of coming up with the defense that you're going to put forward on behalf of your client. It also requires the plaintiff to commit on paper in a court filing to the direction they're going with the case. So keep those two things in mind, and it'll provide an advantage to you and your client. We all make mistakes. We all misdiary things from time to time. We all miss deadlines on pleading requirements. And like I said earlier, the only deadline that you really need to be worried about is the statute of limitations. That's the only one that's fatal to your claim. For all other deadlines, keep in mind that Illinois Supreme Court Rule 183 exists. That allows you to go into court and seek additional time to file whatever pleading is necessary or appropriate or required, even if the deadline is already passed. So keep that as a last resort, but make sure to file the appropriate motion with the court to seek that additional time whenever you find yourself missing a deadline or in danger of missing a deadline. If you keep those helpful hints in mind, it'll alleviate a lot of stress and promote efficiency in your practice when it comes to pleadings. Also, please refer to the ISBA's website for additional information and resources regarding pleadings.